and want to thank GHI Life Sharing for sponsoring this workshop in particular. You can see all their information there, and the Jacob's Ladder and Nadler Biernath for sponsoring the whole workshop this year. So DJ, I'll let you take it away.
Thank you. All right, hello everyone. Thank you. I think I've met a bunch of you out there, so it's good to see you again. I've not done this in person in a while, so bear with me if I'm a little bit rusty. Okay, so what we're going to talk about today is just a common sense understanding of what you need in place if you have a special needs child. This is not meant to be the basics in terms of the documents. It's comprehensive. Every parent's worst nightmare is who's going to do what I do for my child if something happens to me. It's a hard question to answer. A good estate plan is the answer to the question, as much as there can be one. Okay, this is the plan of what's going to happen if something happens to us or a spouse. So if you have a special needs child that is going to need support after you're gone, it's not a question of if you need this, it's a question of when. Okay, so while I'm a special needs parent as well, I know life's so busy. If it's not on fire and stuck to the bottom of your shoe, it tends not to get attention. And I understand this is not that. I get that. But we can't lose sight of it either, because we have to avoid the catastrophic, which is this. All right. I have to say this. I'm not your lawyer. I'm not giving you particular legal advice. If you want any, call me. We'll just move on from that. And a little bit about me. I have had special needs experience before my son was born. I've worked for the Department of Community Health, which of course runs the Katie Beckett program, the now comp waiver, the GAP waivers, all before my son was born. And so kind of had that experience. Went to law school here at Emory. I've been practicing for 23 years. Right now, besides having my own firm, I'm also a judge in Gwinnett County. So a lot of the stories I'm going to tell you, I see this from three perspectives: lawyer, setting it up; judge, where it goes wrong, okay, and as a parent. Okay, so we're going to kind of hit this from all angles. This is why I do what I do. This is my son. Oh, thanks. He's why we do it. Okay. The reason I want you to know I'm a special needs parent is this is your plan for your child. This is not the attorney's plan for your child. We help you get where you want to go. Okay. So approaching this as a parent first, and then the law is the tool to help you get there. So what are we doing today? Like I said, common sense understanding of what you need. Choosing the major players. Okay, it's not just about the law. It's not just about putting names on a piece of paper. Who are these people? How's it going to work functionally? If you have a young child, my child's 12 going on 13. Everyone I name in that plan, future guardians, future trustees, they're all going to pass before he does. What happens then? Do we have an answer for that? Do we know what the answer is, or have we left it up to the attorney? Because again, if you've left it up to the attorney, that's their plan. That is not your plan. And finally, there are a lot of good attorneys that work in this area. Nadler Biernath is out there, and they sponsored the conference. They're good. Pick an attorney who you're comfortable with. I mean, and who specializes in this area. There are a few. Do not go to a generalist. I can tell you why later, but I want to kind of get to the meat of what we're doing. I will give you a trick on generally what you want to listen for to see if the attorney on the other side of the table knows what they're talking about. Okay. All right. These are the documents in a good special needs estate plan, in my opinion. These are the documents I have in place for my own family. I do not have anything in addition to what's on this list. A lot of what, hey, Quinn, a lot of what's here is not just protecting our child and ensuring their future. It's making it easy for the people who have to support your child when you're gone, right? Because the easier we make it for them, the more successful they're going to be, which means the better your child's going to be cared for. So again, it's kind of a bigger holistic plan. Everyone needs a will. Special needs, no special needs, doesn't matter. You need to have a will, otherwise you're going to go through probate and it could be messy and long, and just get a will. Special needs trust. That is where I'm going to talk about the longest, but it's not just about the trusts. I'm going to tell you what it's for. I'm going to tell you how it's created and generally what you can and cannot use it for. Who here has a special needs trust in place? Okay, a handful. Do you all know what you can and cannot use it for? So I see yes, I say no, I see no, I see maybe.
A little bit.
A little bit.
A little bit.
Okay.
Yeah.
We have to know. Because if we don't know, how will our successor trustees know? Right? I'm going to tell you exactly what that is. Common sense understanding. Advanced medical directives, financial powers of attorney. Everyone needs that. If you become incapacitated, who's going to make decisions for you? Why is that important? Because if you're incapacitated, that person who's helping you, who else are they helping? Your child, right? So we have to make it easy. HIPAA waivers. I'm going to talk about why that's useful. Legacy statement, I'll get back to at the very end. The letter to the guardians, if any of you have ever done a consult with me or seen me speak before, I am passionate about this. I'm going to hammer this home. This is the instruction manual to our child. So if something happens to us, are we setting up our guardians who step into our shoes? Are we setting them up for success or failure? Okay, and we'll go into that. We're going to talk about what happens if let's say it's a car accident. Okay, one or both parents are involved in it. Who do first responders call? What happens in the first 5 or 10, 15 minutes, 30 minutes, 1 hour? What's happening with our child? It's not just about 40, 50 years down the road. It's that first 30 minutes, right? Like I said, comprehensive. Finally, we're going to talk about choosing a good guardian and choosing a good trustee. Trust guardians over the child, the trustees over the money and the trust. Should they be the same people? Should they be different? How do we put protections in there? Okay, we're going to talk about that. All right, let's just jump right in. Special needs trust. What is it? Well, first we need to know what a trust is. Trust is meant to hold assets. Well, what does that mean? Cash, accounts, property, business ownership. If anyone has their own business and that business might survive them, you want the ownership to go to a trust. A trust can hold business ownership. Okay, just a bucket to hold things. What makes a special needs trust special? Anything you put in a special needs trust, the government ignores, that guy's the government, ignores in determining your child's resource-based benefits. Well, what are your resource-based benefits? Medicaid, Kitty Beckett, SSI. If your child is getting any of those things, or you want to preserve their ability to get it in the future, you need to contemplate some sort of special needs trust. All right, that's it. That's what makes a special needs trust special. Not hard. All right, big picture. If you ever go out there and you Google special needs trusts, this is what most people are going to talk about, first and third person. You really don't need to know that much about it. If we do this right and we plan ahead, it's a third person special needs trust. Why do we want third person special needs trusts? At the end of your child's life, whether that's 90 years old or 30 years old, whenever it is, with a third person special needs trust, when your child passes, the money goes where you decide it goes. If you have other kids, it's critical because you want to go to them or to their kids or to their grandkids. But that's third person special needs trust. Medicaid cannot touch the funds. First person special needs trust is when we have not planned ahead and somehow money ends up in our child's name. And then somebody comes to me and says, DJ, they now have money in their name, but we need that Medicaid. That's critical. We have the waiver. We're about to lose our waiver. Well, what do? I yank it out of the child's name and I drop it into a first person special needs trust. The penalty for that is at the end of your child's life, Medicaid can take what's left in that trust. So think about the problem there. We want to fund our child's special needs trust with enough money to support them through their life. How much is that? I don't know, but it's a lot. If we don't plan ahead and Medicaid can take what's left, that's a chunk of whatever your life insurance would have been, whatever your estate is worth. So it's just plan ahead. I'm not going to go into this any more than that. Occasionally, if you have a settlement, I had one parent mention about potentially a personal injury settlement that belongs to the child, then you don't have a choice. It has to go to the first person trust. But in general, when we're talking about estate planning, plan ahead. If we do it right, it's going to be the third person special needs trust. All right. Down on the bottom there, I don't know how to get rid of this thing. Just drag it. Yeah, I'm not going to mess with it. All right. Down here, it says pooled special needs trust. That is another option. I'll explain it very briefly. A pooled special needs trust is a giant special needs trust that is run by a professional trust company. Okay, that's it. We're not creating a trust for your child. The trust has been created by someone else. It's been approved, it's professionally managed, has CPAs and lawyers and financial planners. Sounds great. Problem with that is you don't know who the actual person managing your child's fund is. As soon as they get another job or they retire, who's running the show? Okay, so you don't get any ways to customize the trust for the benefit of your child. So not to say that's a bad choice. There are some times when that's appropriate, but those are basically the three types of trusts out there. All right, we know what you use the trust for: preserving current or future resource-based benefits. Two ways to create the trust, and I always give my client these choices. I do know some firms out there do not give this choice. The first way is testamentary. All testamentary means is it's built into your will. So we draft a will for you. There's a section of your will which says anything, I'm just gonna use my son's name, anything to Kai goes to Kai's special needs trust directly, never hits his hands. What happens is when you pass away, your will goes to the probate court. The court looks at it and says, this looks fine. They do that at the beginning of the probate process. So we're not talking about a long time. They say, this looks good, we approve it, and then the trust has sprung to life once it's approved by the probate court. Well, what does that mean? It doesn't exist until you die. It's a blueprint. Okay. So can you fund a blueprint early? No. Most people fund it with their estate or their life insurance. Okay, that's the main way most people fund a special needs trust. The other option is we create the trust for you right now, completely separate from your will. Okay. It's an empty bucket. DJ, I don't want to wait to get that bucket till I die. I want the bucket right now. There are pros and cons between those two choices. The pros to the testamentary trust is it tends to be less expensive. from a legal fees drafting standpoint, which is why I want to give that choice to my clients. There's no such thing as a wealthy special needs family. So I like to give people a choice. So testamentary, I'm just drafting a section of your will. Okay. So I'm not creating it, so it's less expensive. There are several benefits to the standalone trust. Okay. One is, and this is the biggest one, some of us are lucky enough to have their grandparents out there for our child who want to contribute from their will or their estate, or right now, just to put some cash in there. Well, can't do that with a testamentary because you'll most likely outlive those people, so it doesn't exist. So you say, well, DJ, I want the bucket now. And then the grandparents point from their will to that bucket. You point from your will to that bucket. Your spouse points to it, all going to the same place. It's easier to manage. Okay. So if you have other people who want to contribute, standalone is an option. The other benefit of the standalone is it's more detailed generally. And every attorney is different. I'm just talking about us. It's more detailed. And the reason it's more detailed is it's completely separate. And so I'll give you an example of that detail. An example of that detail is in the testamentary trust, it says, trustee, you will have all the power allowed a trustee under Georgia law. Well, great. We generally want to give them lots of flexibility to do what they need to do, right? In the standalone trust, we list every single power out. Every single one. Some of our clients don't like some of those powers. I am glad to tell you when we get to questions, you can ask me what I have personally done for my own family's estate plan. I am glad to share that with you if you think that would be helpful. One of the powers I took out of my trust for my son is the ability of the trustee to invest the trust funds in real estate. Don't like it. I don't want the trustee saying, wow, this is a great opportunity, and then the market tanks. I don't want the money tied up in a security like a mortgage. I want it flexible. So I said, we're just going to put the word not right next to that power. You shall not have the power to invest in real estate. You shall not have the power to invest in a closely held business, right? If it's the trustee's brother and someone opening up a, detailing shop, maybe not a good investment. So again, it's that detail where you can read through as the creators, but again, this is how you detail this trust. I can hit print on our system, that's going to spit out all the powers. The more time and care we take up front, the better our plan is going to be. Okay? So create it now, create it later, pros and cons to both. So we know what it's for. We generally know how it can be created in your will or outside of your will. Oops, wrong one. Okay. All right. For those of you who had a special needs trust, big picture, and this is constantly litigated. So no one take a picture of this. Stop. I see your phone. Stop. You cannot use it for food or shelter without a consequence. Now, you're all thinking the same thing, which is the same thing I thought, is when what good is it if we can't use it for food and shelter? Well, what the government thinks is this. And remember, when I say government, this is Social Security, this is the federal government. They're saying, well, once you're getting SSI, we're giving you Medicaid, so we're giving you health care. We're going to give you about $780 a month. That needs to be used for your food and shelter first. So you see the strategy here, right? You're not touching the trust funds, you're using your SSI cash for that. Now, if you do need to supplement for food and shelter, your child has an ability to get into a better condo, but the 780 is not going to cut it. And you're cutting a check out of the trust for $300 a month to supplement rent. Do not remember this because this changes all the time. But right now, the rule is 1/3 of the payment out of the trust is reduced from your SSI cash payment. Okay, $300 a month. I do easy math because I'm a lawyer. That's why I went to law school. $300 a month out of the trust. 1/3 is 100. Your 780 has now become 680. All right, which kind of makes sense. They want to make sure people are not sitting on the beach in Miami and pulling down all this stuff.
Does that do the same for SSDI?
No. So SSDI is not a resource-based benefit. It's a functional benefit. So no, it's not the same. Okay. So generally food and shelter. What can it be used for? Everything else. Okay. Education, travel, hobbies. We know with a lot of our kids, the problem is when they age out of school is what do we do with them? Right? It can pay for all of that. Transportation, companions to take them out into the community, professional fees. It can pay for all of that. Okay. The reason I say don't remember the food and shelter rule, other than it's food and shelter. This is important, and this is the key to know if the attorney you're talking to knows what they're doing. One of the most important things in the trust is the discretion you give your trustee. Okay, you decide what that is. And I'll give you an idea. There's a slide later, but just let me tell you now. There are different ways to set that up. It can be any way you want it to be. It's up to you. If the attorney does not raise this with you, that is a problem. So for a special needs trust, you can say, trustee, you can do whatever you want with the money. Just give Kai the best life possible. Well, that's a pretty liberal standard. Okay. There's the other side. Look, we don't have much money in this trust. This is a safety net. Trustee, you shall not spend the money if it reduces my child's public benefits. Well, restrictive, right? But serves a purpose. I'll tell you what I drafted in mind. Right down the middle, which is trustee, you can use this money for any purpose you want to give my son the best, happiest life possible. But before you use it for food or shelter, or for anything else that may reduce his benefits, check with a benefits planner. Check with a CPA, check with an attorney, somebody who can tell you the impact before you cut that check. Because I will tell you now, this is a case of an ounce of prevention and pound of cure. You don't want to start messing with SSI or Medicaid to be like, oh, no, we didn't mean it. Can we reverse it? You take care of it up front by, I call it warning signs. I put up caution signs for my trustee. Hey, just be careful on these things. Everything else you're good with. With these, let's just slow down and make sure you have all the information you need to make a good decision. Okay, does that make sense? All right. So special needs trust. Well, I'm going to get into trustees in a minute. We know what it's for: protect current and future benefits, resource-based benefits, which is SSI, Medicaid, Katie Beckett. If you have those benefits, any one of them, or you think you will get them in the future, you have to contemplate a special needs trust now, because that means we're contemplating a third person special needs trust, which keeps the money out of Medicaid's hands. We know how it's created: testamentary, standalone. That's all you need to know about a special needs trust. Now, there's a bunch of legalities in there, of course. We have to comply with state law. We have to comply with SSI law and regulations. But that's what the attorney does. That's not functional decisions you have to make, because that's something we have to do. There's no choice. These other things you have a choice with. Okay. I will tell you this, for most of if people have more than one child, special needs child and a typical child, which I do as well, the hardest decision you're going to make is how to split your estate between the two kids. Right? Because we are raised, I'm Indian, but I was raised here. You can tell by my lack of accent, but we're taught in America that how much we leave our kids is how much we love them. And we have to disabuse them of that notion. We have to make a functional assessment. Hopefully, I mean, my daughter's young, but hopefully one day she'll support herself, hopefully. My son's not going to have that opportunity. And so, do I leave my estate 50-50? It's a very personal decision. At the end, if anyone wants to know, I can tell you how my wife and I approached it, but it's not 50-50. Okay. So, but remember, the special needs trust is for your special needs child. Anything else you want to do for your typical child, even though technically they can share a trust, which is just a terrible idea, you want a regular trust for your other child, if they're, under a certain age. Those are separate. So you have to make a decision now, how much goes into the special needs trust bucket, how much goes into the regular bucket. Now, you got to make that now. It can always be changed. As long as somebody's alive, it can always be changed, okay? All right. Before I go any further, any questions about the special needs trust? I'll take questions at the end again. All right. Is everyone with me? All right. Let's talk about guardians. Who needs a guardian? Well, anyone under the age of 18 and any incapacitated adult. All right. Well, what does that mean? Under 18, we all understand that, right? Something happens to us, someone needs to step in and be the parent. Got it. When someone turns 18, that's where it gets a little murky. In Georgia, when someone turns 18, and I understand guardianship was right before me, so I'm not gonna spend a ton of time on this. They become an adult and have all the rights of an adult, okay? Unless it's taken away by a probate court, which is the process of guardianship, okay? So do you want guardianship? I feel the same way. Everyone's like, wait a minute, I fought my entire life to protect my child's rights. And now you're telling me I've got to take them away from them. It just doesn't feel right. I don't like it. I'm not sure I want to do it. What are your options? Power of attorney is really the only other option. There's supported decision-making out there. Let me not mince words with it. I hate it. And I'll tell you why at the end. Well, I'll tell you why now. What supported decision-making is called good parenting. It means talking to your child, whether they're a minor or an adult, and try and guide them towards a good choice by explaining the pros and cons. That's supported decision-making. To me, that's good parenting. And you can do that within guardianship and within power of attorney, okay? With guardianship, those rights are removed from the child and revested with the parents. With power of attorney, it is not removed from the child. The child still has all of their rights and power. They're empowering you as the parent to exercise those rights on their behalf. That's what's called power of attorney. It's like somebody hired me as their attorney, but I work for them. They don't work for me, right? So your child still has all their powers, and guess who can veto who? Right, that child can veto you if you use power of attorney. Is that bad? No, not necessarily. It's a personal decision you have to make, but you do have to understand, and the example I give, I say it's a healthcare power of attorney. Child has to have a root canal. And we know all our kids learn how to use YouTube. That is the first thing they learn how to use. And they look up root canal and they go, hell no, I'm not doing that. You set it up, you got the oral surgeon, you're ready to go, and they say no. Power of attorney, it's not happening. The answer is no. Guardianship, it can happen because you make the healthcare decisions. Okay. What are the rights that are removed from your child? Their ability to drive, ability to get married, ability to enter into a contract. Okay. There is I said in the beginning, we're going to do a common sense understanding of things. Where I see this go wrong from my judicial work is the power to contract. Okay. And that's that dreaded credit card story. It's not my story. It wasn't my client. It was someone else's client. But they had a high functioning adult son with autism. Part of his chores was to get the mail. Well, he had turned 18, and this was a while ago. But it's when you got the credit card. Hey, do you want a credit card? And what did they say? It's free money. Point being, you don't have to make a payment for 12 months. Well, he was high functioning enough. He filled it out, sent it in, got his card, ran it up. It was $3,500. Because what happened when he got the card? What do all of our kids want more than anything else?
iPhone.
Well, more than an iPhone. They want friends. They want friends. Well, what do? Look what I got, right? People come out of the woodwork to take advantage, and they did. So he ran it up. The bill came in. The parents saw it and said, what is this? They called the credit card company. Look, he's got an IEP. He has an autism diagnosis. What do we do? And they said, we're so sorry. Where's our check? Right? Because under power of attorney, that child has the right to enter into that contract. Under guardianship, they do not. It is void from the beginning, like it never existed. So what if you do power of attorney and that situation comes up? You're not completely stuck. You can go to court and show that judge that your child did not understand what they were doing, but that burden's on you. Credit card company, are they going to have a lawyer? Yeah, they're going to have a lawyer. Are you going to need one? Probably. Is that going to be more than $3,500? Probably. So you see where it gets a little sticky. There is no right or wrong answer between guardianship and powers of attorney. When you have someone and you just don't know, the advice I give clients, try power of attorney. It's less expensive. You don't have to get the court involved in your life. It's just signing some documents. Okay. Your child has to understand what they mean. Big picture. I'm letting mom or dad continue to do these things in my name. That's all they need to know. Or need to understand, I should say. If it doesn't work, you try that for 6 months and you're like, this is not working, they're fighting me too much. Move on to guardianship. You can always escalate to guardianship. Okay. Likewise, guardianship, let's say your child just needs more time to mature. Guardianship is always reversible. Does not have to be permanent. Okay. So like I said, I don't know what the other attorney spoke about guardianship, so I don't want to spend too much time on this. To me, as a parent, the most important right that's taken away is the ability to enter into a contract. If you start with that question, the rest will kind of fall into place. Okay, let's talk about choosing a good guardian. I see this go wrong all the time in a special needs context. The very first one is, how old are they? I can't tell you how many times I see people come in and the grandparents are the guardian. Is that a problem? Yeah. It might not be. I don't know. How old are the grandparents? You know, are they 55? It's probably not a problem. Are they 80? It's a problem. Think about the energy it takes you to be successful at what we do for our kids. And do these people have that energy? Well, what goes into answering that question? How many kids do they have? If they have 5 kids and you're giving them 2 more, that's a lot. That's a different energy level right there. Okay. How old are they? What is their health like? This is the one I hear a lot. And I don't mean to knock on any parents, but I almost think it's kind of funny when you think it through. Oh, my guardian lives, you know, they're part of the special needs community. They have a severely disabled child too. And I'm like, okay, let me just tell you from my perspective, my wife and I are stretched thin for everything we have to do for our 2 kids. If we put another special needs kid on top of that, my head would explode. I would not be a good choice for guardian. Okay, you got to ask these questions. Do they have an established relationship with your child? Does your child know who this person is beyond once a year at Christmas? Right? I get a lot of, oh, well, they live in California. I'm like, okay, that's great, but how often do they talk? Do they FaceTime? Do they do anything? Well, they see them at Christmas. Well, that's not a relationship, right? I mean, I'm not saying that's a wrong decision, but you got to think about it, right? If there's somebody in your neighborhood who's your second choice, who they see every day and they play with their kids and they go to the same school, you got to weigh the pros and cons between those choices. If they live out in California, is your plan for your child to go live with them? Or can we incentivize someone to come and live here? Well, why would we want them to live here? How long did it take you to put together your therapy network? It took us forever. It's a constantly moving thing. Your specialist, your primary care physician, your support system. If your child goes out to California, you're starting from scratch.
Yep.
Is that a problem? I don't know. It depends on your choices. I do encourage people to think beyond family. You know, I mean, it's hard. If you limit yourself, are there other better choices out there other than the fact that they may not be a blood relative? None of the guardians for my child are blood relatives. None of them. In your will, you do want to name more than one backup. Because remember what I said at the beginning, everyone we choose as a guardian for our kids will probably pass away before our kid. Just because of virtue of being older, right? Who's the backup? And here's the really important part on this. What is the mechanism to choose the next guardian if all those people are gone? What is the mechanism? There has to be a mechanism. Because if there is not a mechanism, it will go to a judge and to Georgia law. And that is where we never want it to end up, right? So it can be a mechanism, can look something like, okay, if all these people are gone, I want my closest living blood relative and my child to both agree on who that next person is. It can be as simple as that. It can be as simple as that. Okay, or the primary care physician, but the point is you make the decision, not the attorney's drafting system. Okay, how do they handle stress? There are 2 characteristics I think every good special needs parent has. And this is my wife will say, well, this is you, this isn't me. And that is the ability to fight. And my wife will fight. And it's the ability to handle stress and patience. Okay. Are they the type of person well, I'll just use my son as an example. If he's in Kroger, he's got Williams syndrome, he hears certain songs, and what happens? Boo, right? Another parent with a Williams, I'm sorry, that's a HIPAA violation. But you're in Kroger, in Kroger, He always hears a song. If you the group Journey, he hears "Wheel in the Sky," he loses it. He'll fall down and start crying. We don't know why. It's just what happens. Okay. We have worked with our ABA therapist on what to do. Help him work through it. Do this, do this, do this. Okay. When people walk by and they give us the look, and we've all gotten that look at least once, or they start murmuring under their breath, our reaction to that is move on. There is nothing to see here, right? Is your guardian going to be that person? Or are they going to be the person who gets embarrassed, takes your child, walks out in the parking lot to avoid being embarrassed and undoing months of ABA therapy? I don't know. You do, but you have to think about it, okay? That's how you go about choosing good guardians. Make sure their spouse is on board. I get this one a lot. Their spouse, the person you're asking is great. I'll do whatever you want. I love that child. The spouse is thinking, what are you signing me up for, right? Or you're going to take time away from our kids, or you're going to take time away from us. So what I suggest you do is when you ask somebody, have them both in the room. You know the person you're talking to will probably say yes. Watch the other person. If you play poker, watch the other person. If you see that oh no look on their face, you need to rethink this, right? Give them time to think about it. Tell them about your average day. You want them to say yes to this because they can do the job. You don't want to surprise them on what the job entails. Okay? Give them time to think. Don't tell them about your best day. Don't tell them about your worst day because you'll never find anybody. but we have to be honest. We have to be honest with them about what they're signing up for. All right. You found your guardians. Great. How do we prepare them for success? And this is what I told you. Well, how much time do I have?
We can be a little flexible since you're last, but technically about 12 minutes.
All right. If anyone needs to leave in 12 minutes, I won't be offended. How do you prepare this is where most people go wrong. You pick somebody great, wonderful. Do they know your child enough to step into your shoes? Right? Make it easy for them. Basics, health insurance. What's your child's social security number? What is their daily schedule? What time does the bus pick them up? Or do you have to drop them off at school? All of the basics. Pass it on to them. Allergies, favorite foods. Pass it on. The more successful you are at passing it on, the better prepared they are to step into your shoes if there's an emergency. Okay? In addition to that, think about all you do for your child every day, every week, every month. It's not written down anywhere. And you have to pass that on. Just to make it through the day, we come up with tips and tricks just to make life work. But if they don't have those tips and tricks, one of two things is going to happen. They'll never know, or they're going to have to relearn it. And that's just a waste of time. So I have different examples out here when my son was little, but I'm going to give you the example that I give people during our consultations. And that is my son's semi-verbal. And so when he wants me to chase him around the house with his little toy shark, he doesn't say, Daddy, chase me with the toy shark or play with the shark. He says, Daddy, Dunna. And he says that because when I chase him around, I do the Jaws theme. I go, Dunna, Dunna. So that's what he hears. If I don't tell the guardian that, you have to put this in context, right? This is a functional thing. One day, my wife and I don't come home. The guardian comes in, my son's not gonna know what's going on, but he's gonna know it's dark. He's gonna know mom and dad are normally home. He's gonna know he's hungry, and he's know mom and dad are the ones who normally feed him. And that's not happening. He's gonna go to that guardian and say, Dunna. I gotta tell him, right? Because if I don't, that really bad situation has just gotten worse. Well, what's gonna happen? He's gonna continue to melt down. He's not going to sleep that night. Not going to sleep that night. He's not going to eat the next morning. Skip all that and just write it down. What is the easiest way to do this? We do help our clients with this when they retain us. We help them pull together the basics. There's a better way to do it. Create an email address for your child that you control. The next time you do something with your child that is a process or a tip or a trick, take out your phone. We always have our phones with us. Record it. And as soon as you're done videoing it, email it to that email address. And then in your will, in your binder, you're going to have that email address and the password. That's better than anything you can write down. Well, what are we videoing? Bedtime processes, pottying processes, brushing teeth. When we brush my son's teeth, we have to look for Santa Claus in his mouth. Don't ask me why, but it's literally ho, 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 is Santa in there? It's just what we do to survive. Pass it on. You gotta pass it on, because once it's gone for good. Everything else in this is not even a legal document, but I can guarantee you anything else in this I can recover from a legal standpoint. Cannot recover this. Okay. All right, I'll get off my soapbox. That one. All right, guardians and trustees. Guardians are over the child. The trustee is over the trust. We don't think they should be the same people. Okay. Guardians and trustees act as a check and balance on each other, because the entire purpose of the trust is care for the child. So the trustee is looking out for the child. The guardian relies on the trust to provide for the child. So they're watching the trust and the trustee. But if you want to make it simpler than that, just remember this. One of the guardian's legal responsibilities is to exercise the child's legal rights on their behalf. Well, what does that mean? It means they can sue someone for that child. Well, if the trustee is stealing the money and the trustee is also the guardian, who's going to sue the trustee? Just think of it that way, and then it becomes clear. It's like, well, that doesn't make any sense. Because once that money's gone, if that person's what we call judgment proof, meaning they have no assets to satisfy the judgment, the money's gone. And it's too late to get it back. So they should be different people. Okay. Always put in protections. Okay. There are basically three kinds of protections, big picture. One is have them be different people. That's the best one. No one on your list of trustees and backup trustees should appear on your guardian list. Okay. If you don't have that many people you trust, so you don't have 3 people on guardians and 3 people on trustees, which is the case for a lot of people, and you're like, DJ, look, our number one choice is the best for both roles, and we want that person. That's fine. We can work with that. What do? You can name co-trustees. Someone who acts as a trustee at the same time as the trustee/guardian. They technically both have to sign off on decisions on the trust. So there's always a second set of eyes watching. If you don't want that, like DJ, that seems complicated. We can always put into your plan something called a trust protector. Well, what does a trust protector do? Whatever you want it to do. What we generally do in our plans is we tell our protector a couple times a year on a random basis, I want you to do an informal audit of the trust. Your power is to get all of the account information and tax filings. And if you see somebody doing something big wrong, you don't want to micromanage, but they're stealing the money. They're failing to write checks in a timely manner to support your child. They're ignoring the investments. They're not filing tax returns. Something big. That protector's power is to remove the trustee from that role without going to court. It's instantaneous. They send notice and it's done. Well, who's the backup to them? Whoever you've already chosen. So that way we are protecting from the protector. If I'm your protector, I can't remove your trustee, put my buddy in place and try and steal the money because you've already chosen the successor and you've chosen the mechanism if all those people are gone. My mechanism says in no instance shall the trust protector ever choose who the trustee is. Completely protected. Okay. All right. I talked about this before about the discretion, full discretion versus less. Just if the attorney does not ask you, if you've already paid them and they're engaged, that you bring it up. Because you have to understand, this is the authority your trustee is going to have for the rest of the life of the trust after you're gone. So make sure you think about it. Just real quick, the advanced medical directive. This is for the parents. If you become incapacitated, who's going to make your healthcare decisions for you? It's important for you to do this for yourselves because whoever is left to make those decisions will probably also have a role in supporting your spouse or your kids. So we want to make it easy. We don't want to have a ton of family discussion. Some of you are probably too young to remember the Terry Schiavo case out of Florida about parents versus husband about whether to let her go or not. This is what avoids that. You got to do this. Basic document in any plan. Financial power of attorney. Same thing. Who's going to make your financial decisions for you? I will tell you one thing we put in our advanced medical directive that's not in the standard form. If you are incapacitated, give some guidance on what you want your life to look like to your agent. Now, I'll just tell you what mine is. My particular one is, even if I'm able to come home, if I can't communicate and I'm unaware, leave me in the rehab center, even if I'm allowed to come home. Because if I come home, I know my wife is now a single parent and she's going to be caring for my kids. And if I'm sitting in the other room being cared for by a nurse, my son's not going to know what's going on. My daughter, it's going to be harder to have me there. But I guarantee you this. If I didn't write that down and my wife knows that's what I want and she leaves me there, oh, my parents are coming for her. Why are you leaving him there? Bring him home. He should be with his family. They're not thinking straight. They don't hear logic because they're grieving in a way for something wrong. Something went wrong. Take care of it all and just write a couple things down. Okay. Child safety and protection cards. You can obviously do this yourself. This is a copy of what we do. If you're in an accident, first thing first, do we have any first responders here? Okay. First thing first responders will do is look at your phone to see if the emergency contact tab is filled out. If it's not, I urge you to fill it out. If it's not filled out or the phone is disabled, the next thing they look at is your driver's license. Okay. This gets tucked behind your driver's license. The first name is your spouse's name. The next two names are people within 30 minutes of your home who can get your kids. Okay. Especially if you have a child who cannot communicate well or has medical needs. We don't want a well-meaning teacher or neighbor or therapist stepping up if they don't know how to care for the child. These are the names of the people who can watch that child until the guardians can get there to take control of the situation. Really important if your guardians are not local, if they can't be there within 30 minutes. They're in another state. I want Sarah Doe because she's fed my child before, so I know at least he can have a meal while they're waiting until the guardians get there. Stick this behind your driver's license and forget it's there. That's simple.
You mentioned your phone. Is there an app for that?
No, well, most of the,
Where-
I have an iPhone now.
Yeah.
So on the bottom, there's a little emergency tab
Oh,
that you can hit. Don't ask me to find it now, but I can,
I'll have to look for that.
it's there somewhere, but that's where otherwise, they can check that by definition. First responders can check that. Otherwise, they need a search warrant to get into your phone. And no one has time for that.
Sure.
All right, let me just give you, my time's about up. Let me just give you a couple of final words of advice. Do not get hung up on making all these decisions before you start the process. A good attorney, we used to be called counselors at one point because we used to actually counsel people to make their decisions. We will help you think through the process of choosing a guardian and a trustee. This is where everyone gets stuck. I've had people hire us, pay half of the fee, and disappear. And I will call them, or I actually have an attorney who works for me. Their entire job is to call them every 6 weeks, say, hey, can we help you? Because look, if it's either in place or it's not. There's no in between. Okay? Don't get hung up. They're hard decisions. Put something in place. You can always change it later. The way I help people think about it. Imagine something happens to you in the next 3 to 5 years and make your decisions based on that. So say the grandparents are 60 years old. Well, 60 to 65, you still have some energy. Maybe that's a good choice for 5 years. Put it in place. And then you can change it. Go back when you're not trying to make all these decisions. Say, let's just look at the guardian, or just let's look at the trustee. Oh, that's it. All right. Questions about anything? I know. Head spinning. Yes, sir.
I have one quick question. An example, if we set this up now, is it specific to just Georgia? If the sibling wants to move them to California, if that's where they have a job or something like that, how does that work? Like, or is this, are there big hangups locally or?
So no.
Okay.
No.
DJ, will you repeat the question so they can?
Oh, sure. So the question is, it's state specific or can it travel? And so other states will honor other states' wills. There may be some additional requirements like, hey, that's fine, but for your will, you need an in-state executor or something like that. Or the bond might be a little higher. But say it's a special needs trust that say it's a standalone. Well, that's a contract between you and the trustee for the benefit of your child. You've chosen Georgia. Doesn't matter where the child is in. You do want to take that trust and show it to whatever state Medicaid agency your child is in, make sure nothing needs to be changed. But is it all wasted if you move? No, it's not. Yes, ma'am.
You said you would share your decisions with your son?
On how to split the money? Okay. So well, what we did, sorry, honey, what we did is we basically said, if we wanted to support our daughter through college, that's food, shelter, entertainment, education. We came up with a number that we felt, and we picked a college that was like an in-state. She better get the Hope, all of that stuff. Okay, and we came up with a number, and then we said on top of that number, we want to leave her with $100,000 to just live her life, pay for a wedding, put a down payment on a house, start a business, because mom and dad aren't there, right? We came up with a number. Everything else goes to the special needs trust. For us, it turns out to be about a 70-30 split. And as a parent, how I rationalize this are two things. One, by sufficiently funding my son's special needs trust, I free my daughter up to live her life without worrying about supporting her brother. Two, I know my son will not have his own family. At some point, when he passes, whenever that is, that money goes back to my daughter's side of the fence because I planned early. Well, what if he outlives her? Well, then it goes to her kids or to her grandkids, but eventually comes back over here. And that makes me feel a little bit better as a parent at doing this. And ultimately, you know, we've been hammering home, you know, money has nothing to do with how much we love you. And, you know, hopefully that'll stick. Anything else? Any other questions of anything? Anything I've said or not said? Yes,
I
ma'am.
have a question. When a child starts getting Social Security, how do you determine what that dollar amount is a month?
Social Security does.
Well, but is it like, is it based off of the level of severity of the child that's diagnosed? Like how do they come up with that
It's a
dollar?
financial calculation. So I am not a Social Security attorney, but the first thing everybody should do is sign a lease between them and their 18-year-old or older child, charging them room and board. Okay, they're going to write 500 out of 780. They're going to write a $500 check to you, because if you don't do that and you're giving it to them for free, Medicaid or SSI says, aha, you're getting free stuff. That's like income. That's like income. So now your 780 is 500. So to maximize the benefit, that's one of the things you have to do. How beyond that?
Start at 18?
I'm sorry?
When do you start that, at 18?
18, here's your cake, sign here. Just real quick, someone asked me how ABLE accounts work with this. Just real quick, ABLE accounts work just like a special needs trust. Anything you put in it, the government ignores in determining your child's benefits. How does it differ from a special needs trust? One is you're capped at $15,000 per calendar year deposited into that account. Two, it has great tax benefits. It works like a 529 or a Roth IRA, grows tax-free on the growth. You have all these investment options I'm talking about Georgia specifically. Every state has one. You can choose from any state you want. Okay. And three, there is Medicaid payback at the end of your child's life. So Medicaid, when your child passes, anything left in that ABLE account, Medicaid can take. There are other differences. Those are the big ones. Yes, ma'am.
Could that ABLE account be set up in the name of trust?
No. So think of it this way. Third person special needs trust is a bucket of completely clean water, right? Your child never had access to it, can't control it, so Medicaid can't get to it. The ABLE account is technically your child's, which is why there is Medicaid payback. That's a bunch of ink. You take $1 of that ink and you put it into clean water and you poison the entire pool. They have to be separate. Now, can the trust fund the ABLE? Yes, it can. And this is something, and I love and hate Facebook. I love it because a lot of people get my name from it, and I'm appreciative of that. But I'll see things on there saying, hey, we got our special needs trust done. Next is the ABLE account. I'm like, no, they work together. Your trust has to have been drafted to fund the ABLE, because you can use the ABLE for food and shelter without a penalty. So how does that work? The money goes from the trust, where you can't use it for food and shelter. You give it to the ABLE. Well, that's income to your child. What's your child's effective tax rate? 0 or something like that, something low, not a big deal. Then the money comes around to pay for food and shelter with no penalty. They all work together. And so you can't be like, hey, I did this and that. It's got to be a full kind of holistic thing. So if you sit down, you bite the bullet, you do all this painful decision-making up front, you work hard up front, the longer your plan is going to last without being changed.
If you have a special needs trust, do you need the ABLE account?
Well, I mean, you may not, but so I've got a special needs trust for my son. I've got an ABLE account. I don't fund the special needs trust because the special needs trust is at a pretty high tax rate. right? It is higher than my personal effective tax rate. So it doesn't make any sense for me to put it in the trust. I just hold on to the money for my son. And when I die, it'll go to his trust. The ABLE account has all these great tax benefits that none of these other things have. And so I do fund that. My son, you know, part of Williams syndrome is a congenital heart condition. What's his isn't bad, but we just don't know. So do I max it out to 15,000 a year? No. Is it 16? Okay, 16,000 a year. I don't fund it to that. If I get a tax return, you know, my wife gets a small bonus. We'll talk, or parents want to leave something, we'll toss it in there. I'm not a financial planner, by the way. That's just what we do. Anything
But
else?
You can't put the SSI money in an ABLE account. It has to go in a separate bank account. And the guardian or whoever is the authorized representative payee or.
Well, SSI can go into ABLE because the ABLE is your child's. And
Okay,
the SSI money is your child's.
correct. Okay,
So it can't go, it's still going to count as income to your
Okay.
child. So you can't avoid it that way.
so I wouldn't have to open up a special bank account for SSI money. I could go into the ABLE.
You could do ABLE, or you can,
We have an ABLE.
ideally, you spend it every month, right? 500, 600 to you for room and board, and then the other 200 and change for whatever your child's expenses are that month. Anything left over, we put in the ABLE.
So I can move it. Okay, I see.
You just want- okay.
Got it.
You want to remind people how to get in contact with you?
No. No, I'm kidding. I've got a booth out there. We've got some brochures. We've got a booklet we put together on just every little, not every little, but the major things you need to consider when raising a special needs child. It's not just the stuff we do. It's kind of everything. Medicaid, now comp, GAP, Social Security. We have those out there. So I'll be out there. If you all have any questions or want a brochure or a card, I'll be out by the booth.
Thank you.
All right, thank you all.
Great.
Yeah.
Not too far.